My name is Ian Alden. Thank you very much for joining us for today's presentation on the differences between independent contractors and employees. Just to give you a few quick disclaimers, if you will. This is a presentation for informational purposes only. It does not constitute legal advice. I'm not your individual legal counsels. I'm not anyone's legal counsel here. This doesn't create an attorney-client relationship, and I do strongly encourage you to consult with your own legal counsel as to your unique situation, because everyone's situation is unique, and it's good to have an attorney in your corner. A bit of guidance on this, which I'm sure is already the case here with the sophisticated Zoom webinar we're on, but make sure your microphones are silenced. We've got 15 minutes reserved at the end for questions and answers, so hold your questions till then. If you have questions pertaining to a specific slide, just make sure you write the slide number down. You can see it in the top left corner of the screen. So we're going to start, I've broken this into 3 rough sections. We're going to start with sort of the legal definitions, because that's really what we're here for, kind of the nuts and bolts of what is the difference between an employee versus an independent contractor. We're going to start by looking at some of the different tests that are applied, whether the tests, by the Department of Workforce Solutions, Department of Labor, or both in some cases. There's a lot of interplay, there's a lot of overlap that we'll cover. We'll move on to why this all matters, because I get that question a surprising amount. Why does it even matter whether they're an employee versus an independent contractor? And we're going to talk just briefly about some of the other implications for, going in one direction versus the other. So as we jump into these definitions, I want to emphasize that you're going to see a lot of common themes here. The biggest common theme, I'd argue, is control. And we're going to talk about what control really means in the abstract, because there's just not a good way for you to memorize or internalize all of these different tests. I mean, very few employers are going to have, these 3 different tests laid out factor by factor and, do their own analysis. So what I really want you to be focusing on, and what I want you to take away from this presentation, is some of the common threads here, the biggest one, of course, being control. So when you ask what is an employee or what is an independent contractor, you start with what is an employee, because we'll see that an independent contractor is essentially not an employee. So you ask what an employee is, and we're going to start with the ABC test with the New Mexico statutory definition of an employee, because that's as good a place as any to start. And this is based and grounded in the unemployment compensation law, but it has tendrils, some far-reaching implications for other governmental agencies and other areas of law. But our unemployment compensation law defines employment as service, including service in interstate commerce, performed for wages or under any contract of hire, written or oral, express or implied. You look at services performed by an individual for an employer for wages and remuneration, unless these 3 factors are met, all 3. If all 3 of these are satisfied, under the unemployment law, they're not considered an employee unless, and we'll talk about what the unless means, but you break it down. If the individual has been, and will continue to be free from control over direction of the performance of services under that contract for service, and factually, meaning in the language of the contract, it says, the party that's hiring the service provider will not control the means by which the individual provides their services. And then, in fact, they don't try and they don't exercise that control. If they do control, if there is that level of control, either in the services contract or in actuality where the party doing the hiring is controlling, say, the hours, the location, the means of work, the methodology, then there's just an automatic presumption under this test and under pretty much every other test that the individual providing the services is an employee. So control is the biggest common thread between all of these tests that suggests an employment relationship, not an independent contractor relationship. But let's say there isn't that control, like under this section A, there's no control. Then you look towards the next subsection here, which is the service is either outside the usual course of business for which the service is performed, or is performed outside of all the places of business for the enterprise for which the service is performed. And I'd like to give a common example of this being like a receptionist, someone who watches the front desk of the business. You really can't have a receptionist who's based in the business be an independent contractor, because they're performing the services just at the business's location. I mean, that's where the services are being provided and rendered. So it almost automatically fails the subsection B. But the idea here is really that if you want to have an independent contractor, you can't just have them working exclusively at your place of business. And then C, and this is a really big one, and you see this a lot with things like owner operators. When we're asking, can they be independent contractors? Are they customarily engaged in an independently established trade, occupation, profession, or business of the same nature as involved in the contract of service? For owner operators, this subsection C is almost always satisfied, which leans towards independent contractor. Because you've got people like that, you've got other common examples, plumbers, electricians, etc. They're engaged in an established trade that's independent of you as the hiring party. Like you are not the only reason they are doing that particular trade or occupation. Going back to electricians or plumbers, if you don't hire one, they're going to go work for someone else. They're going to provide services writ large to the general public. So they're independently established. So those are the three bits of the ABC test, which I'll talk about a little bit more. But looking at New Mexico statute, this is a great place to start when you're looking for the definition of an employee. Because if you fail any of these 3 points, they're an employee under New Mexico wage law, under New Mexico unemployment insurance law, and that just has ripple effects throughout the other analyses. So I should mention we're going to be covering 3 or 4 different tests. A common question that I get is, well, which test do I need to satisfy? Which test matters to me? And people don't like the answer I give them, because the answer is really all of them. It doesn't help you, like, let's say you want to have an independent contractor. It really doesn't help you if you pass the IRS's test for independent contractor relationship, but fail the DOL's test or the Department of Workforce Solutions test. If any of these tests consider someone an employee, functionally, they're an employee across the board, because you can't split the baby. You can't do a Solomon split here and say they're an employee for IRS purposes and an independent contractor for everything else. It just doesn't work that way. So we're going to cover a lot of different tests, but if you really want to have independent contractors, you need to make sure that their relationship satisfies all of these tests. So this is the ABC test. In my opinion, it's kind of the simplest of the lot of them. It's applied mainly at the state level. You see it baked into our state statutes. It's similar for California and a couple of other states. The federal government tends to give some deference to it. So when states have these statutes, the federal government will factor that in a lot of instances when they're doing their own analyses. But then you look at what's an independent contractor. As I mentioned earlier, they're basically not an employee. If you have someone providing services for you who does not fall under the definition of an employee under any of these tests, they're an independent contractor. So long as you define the relationship that way and you declare them as such. It's just an if not employee, then independent contractor test. So really, you see independent contractors commonly used, like I mentioned, third-party service providers who provide these services to more than just one party. That's the most common example of independent contractors, is they provide services to the general public or to some number of other customers or clients. It's very rare that you have an independent contractor with an exclusive services relationship, which we'll talk about a little bit later in some of these other tests. But that's what you're looking at. So going back to what we were just talking about, what we just looked at is the ABC test. It is the bedrock state level test to see if someone is an employee. If you meet the requirements for A, B, and C, then they can be an independent contractor. But if any of them fails, they're an employee. So you look at the first test, section A. Has the individual been, and will they continue to be free from control or direction? Like I said, it's not enough to say in the contract they're an independent contractor, but then you exercise that control. In any kind of audit situation, they're not just looking at the language of the employment or independent contractor agreement, they're looking at the actual practice, what you really do with these people. So keep that in mind. I have a lot of clients who come to me with independent contractor agreements saying the state's accusing them of misclassification. And the first thing I ask is, well, how did you actually interact with them? And then the whole thing falls apart. So just remember that you have to actually let them be free from your control or influence. You can't direct the way in which they provide services. You can't direct necessarily where or how, except in instances where there's like a specific job site that you hire them to perform services in. I do get that question a lot in the construction industry. Let's say you've got a job site, you need them to do a specific job. Is hiring them to do that specific job considered control such that it fails the ABC test? Not necessarily. If you're telling them they have to provide the services at the job site, that's just part of the scope of services, and that's acceptable. If you are directing at kind of like a micromanagement level how they provide the services, the methodologies, the means by which they do what they do, then that is control. And it's a complicated nuance to grasp, but you just have to really look at each individual situation and make sure that you are not micromanaging or directing with specificity how they do their job. The second part of the ABC test, outside the usual course of business for which the service is performed. A common example of this is if you are selling, like let's say you are in the retail business, like you are selling home goods, and you try and staff your store with independent contractors who are going to work at the store and sell your home goods for you. They're essentially engaged in the same business or enterprise that you are, and they're doing it on your behalf. You typically fail the part B of the ABC test then. There's some weird nuanced exceptions to this when you've got vendors providing their own contractors who are selling on your sales floor, but that's a very different dynamic or relationship. The part B of the ABC test, in my opinion, is the most murky. It's kind of the most convoluted of them. But the gist of it is, you can't sub in independent contractors where you'd very conventionally have employees. And I use the examples of cashiers, receptionists, and on-premises sales staff as the big three. And then the third part of the ABC test, they have to be, in order to be an independent contractor, they have to be customarily engaged in that independently established trade, occupation, profession, etc. Independently established is a really interesting bit because the state gets a little weird if you are getting them established into that trade or occupation so that they can service you and your company uniquely or exclusively. You're going to fail this part of the ABC test then because they're not independently established at that point. So really, independent contractors, they should have already been in business prior to you hiring them, is the way I like to frame this for people. Tradespeople pretty easily clear this hurdle. Owner operators are another great example. When in doubt, look for case law. I say that just because the devil's in the interpretation when it comes to this ABC test. So there's one case that I'll cover in a little bit that kind of walks you through some of this stuff, but sorry. I want to move on to another test that has broader implications. The ABC test is very much a state level test for our state level governmental agencies and programs, unemployment insurance, Department of Workforce Solutions, et cetera. But there's another test that you need to know. I like to call this the once and future test, because there's a rule in place right now that superseded this, that's about to get superseded by this. We're essentially going back to this, but it's called the economic realities test. This has been the test that's been applied in federal jurisprudence and federal case law, and by the DOL and federal agencies for going on 70 years, give or take. I mean, it's been in place for a long time in various iterations. Our DWS, or Department of Workforce Solutions, does consider it alongside the ABC test. So on the off chance that you satisfy the ABC test but don't satisfy this, DWS is still going to consider someone an employee. It's like I said, at the end of the day, you need to satisfy all of these tests for someone to be an independent contractor. The economic realities test, it's similar in a lot of ways. The common theme, again, is control. You look at the extent to which the worker services are an integral part of the employer's business. Do they perform the primary type of work that the employer performs for their customers or clients? This is part B of the ABC test. Basically, does what the independent contractor is doing so closely aligned with what business is doing that they're not considered distinct or separate? Common example, again, is salespeople. Another common example is management. It's a really weird thing to try and hire an independent contractor to manage your employees. As a general rule, I tell people don't do it, because they are A, being controlled to some degree by you as the upper management, and B, they are becoming an integral part of your business, such that you're going to fail part one of the economic realities test. You look at the permanency of the relationship. Independent contractor relationships are by their nature transient. They're not meant to be ongoing for forever. I mean, they can have an unlimited duration, but the idea is that they're ultimately temporary. You can sub out an independent contractor, and typically you will. It's a little weird because permanency of the relationship, I'd say this is weighted maybe a little bit less if you have a long-standing independent contractor relationship, but it's still something that they'll look at. If you've used one person as your independent contractor for 20 years and they're providing substantial services for you, that weighs in favor of misclassification. It suggests that maybe they're really an employee. Number three, the amount of the worker's investment in facilities and equipment. Are you covering the independent contractor's equipment costs, materials, supplies, materials and supplies for construction for a job site? That's somewhat normal, but equipment is not. So if you're buying equipment for the independent contractor to use in the provision of services, that suggests employment. Typically, you want the independent contractors to use their own tools or equipment. You look at the nature and degree of control by the principal. Again, this goes back to part A of the ABC test. Control, who really has it? Who's dictating the hours worked, quality control, the means and methods of services provided? You look at, does the worker work for any other companies? It leans in favor of independent contractor dynamics if they work for multiple companies. It leans towards employment if they only work for you. If it's an exclusive relationship, whether by design or otherwise, it leans more towards employment rather than independent contracting. And then the final parts, this is a 6-part test. You look at the workers' opportunities for profits and losses. This is a fun one. Put a pin in this because this is at the heart of a recent change that's getting rolled back on the federal side. But you look at the workers' opportunity for profits and losses. For example, did they make any investments? Can they earn a profit by being more efficient? For example, if you hire an independent contractor, if you subcontract out on a job, you're typically subcontracting for a set amount of money, and then that subcontractor, they can spend as much or as little as they want on labor costs as long as they get the job done to spec. And so you look at, do they have that kind of flexibility? What is their skin in the game, and what is their opportunity for profit or loss? If their labor costs exceed the amount they're getting paid for the job, who bears the risk of loss? If it's you as the hiring party, that leans more towards employment. If it's them as the contracting party, that leans towards independent contractor dynamics. 6, the level of skill required for performing the job, the amount of initiative, judgment, or foresight. This is a test that cuts both ways a little bit, but the way I like to look at this is if you're hiring someone for a very menial job or an entry-level job that doesn't really require prior training or expertise. Again, I go back to like receptionist or something like that, where they kind of learn on the job and there's not really a base level of training that you need to do the job. That leans more towards employment. Independent contractors, you typically hire them because they have a unique skill set that can't be done by any general employee. You go back to tradespeople, you go back to construction subcontractors, things like that. Is there a reason why you would hire them as an independent contractor? And then, of course, this kind of dovetails with section C of the ABC test. Do they have their own independent business? So let's put a quick breaker there, because those two tests, the economic realities test and the ABC test, taken together, govern a lot of state agencies and how they view the employer versus independent contractor debate. They're going to apply those two tests. The weighting, in my opinion, on each of the factors is a little arbitrary. Like, you might see them make an argument that one factor is overriding. Typically, that's going to be either control or the independent business, like A or C. But those two tests are very important. And so if there's only two tests that you really walk away with an understanding of, it should be those two. That said, on the federal level, we have what we're calling the 2021 Independent Contractor Rule. That replaced the economic realities test. It was published January 6th, 2021 by the Trump administration. If you're looking at that date and scratching your heads a little bit, that was 2 weeks before Biden took office. It was a very late stage bit of rulemaking. It was published, January 6th. It made it much easier to classify workers as independent contractors instead of employees, because it whittled the 6-factor economic reality test down to 5 factors and then disproportionately weighted 2 of them. So you've got these 5 factors listed here, which are just 5 of the 6 you already saw. But you look at the workers' opportunity for profit or loss and the degree of workers of control, like who has control and who has the opportunity for profit and loss. Those are very disproportionately weighted, with a lot of emphasis on opportunity for profit or loss. It's allowed a lot of employers to sort of thread the needle and say, well, this person, we're giving them some latitude in terms of control, and they can profit or loss at their discretion. This is an open market, free economy. If they want to put in the initiative, they can profit. You kind of disregard, or at least put to the side, a lot of the other factors and considerations. Taken as a whole, this test is very deferential towards people doing the hiring to determine if someone is an employee or independent contractor. The reason there's such an asterisk by this rule is Biden took office 2 weeks later, and has spent the last year and a half trying to get rid of it. His administration declined to implement or enforce it. Someone went to the courts and the court said, you have to enforce it. It's a published rule. So now, just about a week ago, maybe a couple of days ago, they published a new rule out of the Biden administration that would do away with this 2021 independent contractor rule and essentially go back to a totality of the circumstances interpretation of the old 6-point economic realities test we just covered. So the rule put out by the Trump administration, frankly, is not long for this world. None of us think there's going to be any impediment to overturning it with this new proposed rule. It's going to take a little while, maybe a couple of months, to go through the motions and then go into effect. But when it does, what you're really going to need to know is this economic realities test. The once and future test is what I'm calling it. So just understand that this is technically the rule of the moment. If you want to enjoy the deference it provides for the moment, you can. But once we go back to the other rule, you're not going to get a grandfather under the 2021 rule. You may find yourself in misclassification scenarios. So I would recommend to people that if you pass the 2021 independent contractor rule for independent contracting, but fail the 6-point economic realities test, treat them as an employee, because it's just going to save you legal headaches down the road. And then finally, in terms of tests, we're going to talk about the IRS common law rules. This is the IRS test for tax purposes to see if someone is misclassified as an employee versus an independent contractor, because misclassification, as we'll talk about, has a lot of tax implications. If someone is misclassified as an independent contractor, you as the employer don't have the obligation to withhold income taxes. You don't have the obligation to pay the employer's half of Social Security and Medicare. That obligation for the employer's half gets punted to the person you hired, who then has to pay both halves, which is effectively 15.3% of whatever they make. So the IRS cares mostly because employees care. If you're a misclassified employee, you're getting the short end of the stick tax-wise. So this is the test that the IRS uses when someone raises a claim of misclassification, or when they do their own independent audit and decide there's been some misclassification. It's 11 factors built into 3 categories. It replaced an old 20-factor test that Congress begged the IRS to change. I mean, basically begged at the pointy end of a bayonet, saying, if you don't change this test, we're going to pass legislation and make you do it. So they whittled it down to 3 categories, which you might seem familiar to you. You look at the control, and you look at the relationship of the parties. Control, you look at whether the business has the right to direct or control the worker, which should seem very familiar. I'm probably going to breeze through some of these slides because you've seen this stuff before. The IRS had the courtesy to kind of enumerate some of these points. You look at the instructions that the business gives to the worker, the training the business gives to the worker. If you're training them up, that lends itself to them being an employee. You typically don't provide training to independent contractors, except for maybe a little bit of acclimation to your own project. So training lends itself to an employment relationship. Yes, these are all kinds of instructions that are worth knowing because they can apply to the other tests as well. When and where someone does work, what tools or equipment they use, who they hire to assist them. If you're subcontracting, but you are directing who the subcontractor can hire, that is a form of control that lends itself towards employment rather than independent contracting. Where they get their supplies or services, just don't go down that road. That way lies madness. What work has to be performed by specific individuals. If you were saying only this individual can perform these services, that's control. What order or sequence to follow, like what order they do the work in, which can apply to construction jobs. If, for example, you are hiring someone to do they're subcontracting a bathroom reno, and then you tell them you have to do the sink first and the shower, etc. That is a sort of control. It's not dispositive control. There might be a reason why you're doing that as part of the project spec based on your work with other contractors, but just understand that it's a thorny issue to control what order or sequence they do the work. The amount of instruction needed varies among different jobs. Again, like you might need to control some aspects to a limited extent, but don't go overboard with it. Yep, if you have the right to control how the results are achieved, even if you don't exercise that right, if it's baked into the contract, that creates a presumption of employment. So you really have to be hands off to a large extent. Yep. If you've retained the right to control the details of workers' performance, or if you've given up that right, that weighs heavily. Financial control. This gets into kind of a weird situation where if you're controlling the finances on an intricate level, it lends itself towards an employment dynamic. The extent of the workers' investment, again, are they buying their own equipment? Are they building their own infrastructure to provide services? If you're paying for all that, if you're buying them their equipment, that can lend itself towards an employment dynamic. The extent to which they make their services available to the relevant market, if they're exclusive, if they're only providing their services to you and they're not trying to market elsewhere, that suggests an employment dynamic. If you have exclusivity in the contract, or if you do something really bad idea, if you try to put a non-compete or something in the independent contractor agreement, that can lend itself really towards inference of an employment dynamic. They have to be able to market their services elsewhere to be considered an independent contractor. And then how the business pays the worker. This matters. You can't have them be W-2 if they're independent contractors. You can't pay them typically on an hourly basis, except for certain service providers like lawyers, doctors, etc. I mean, you know, you can't have them be W-2 hourly or salaried independent contractors is the gist of this. And again, you go back to what the extent to which they can realize a profit or loss. If they are the masters of their own fate to an extent, with respect to their own business, and you know whether they can run a lean operation or not, that makes a difference. And then the types of relationships, written contracts. If you say they're an employee by default in the contract. If you say they're an independent contractor, that suggests an independent contractor relationship, but you still have to look at these other tests. If you're providing employment benefits, they're an employee. Don't do that. Don't give them vacation, sick pay, a pension, retirement. Don't give them employment benefits. In a lot of instances, you can't anyway, but just don't try to do it, because if you try and create employment benefits for your independent contractor, it strongly suggests they're employees. And then again, the permanency of the relationship. If it's permanent, of an indefinite duration, it suggests employment. And the extent to which services performed by the worker are a key aspect of the regular business. Again, this is part, this is part B of the ABC test. If they provide the services that are a key aspect of your regular business, you're going to exercise a lot of control by default. You know, an example that the IRS gives: if a law firm hires an attorney, it's likely that they'll control the work, yada, yada. If you control the work, employer-employee relationship. A trucking industry example. This is provided by the IRS, and I love these because if the IRS provides an example, which they do in their regulations and they do in their helpful hints sections of their website, you latch onto those examples because that is as close to a safe harbor as you get, unless Congress just gives you one in the law. You know, if Ross Trucking contracts to deliver for Forest Inc. material at $140 per ton. You assume this is an independent contractor relationship. They're not paid for anything that isn't delivered. Jan Rose might, lease another truck and engage a driver to complete the contract. She might subcontract. All of these expenses of the business are covered by the trucking company, not by the client or customer. All the equipment is owned or rented by the trucking company. They pay for the maintenance. None of the drivers are provided by the customer or client. They're a very clear-cut independent contractor. And this is what you like to see. You like to see these clear and obvious examples, and you want to be on this side of things. You don't want to be in the murky gray area where maybe you're asking the customer to provide the truck, or to provide drivers for the truck, or to provide insurance, or to provide maintenance. No, you want to have a clear distinction between the hiring entity and the business being hired. There's some case law. I'm going to skip through this in the interest of time. It generally just reinforces what we already talked about with the ABC test. The state court has really just looked at this thing, and they have weighed in that it's a valid test. It still applies today, even though it's kind of an old test. It's now baked into statute, and so the interpretation, the short version is it's pretty deferential to the government entities, but it's not entirely deferential. If you can make a good showing that you've satisfied these tests, and then a government agency says, no, you've misclassified them anyway because we feel you have, you can win in court. And I think that's really the biggest takeaway from case law. This case right here, it's a 1986 case, but it suggests that you do have recourse if you have independent contractors and some government agency says, we think they're employees. Why does it matter? And this is kind of important thematically for today's presentations. A lot of RFPs and contracts have employment-related goals and metrics. DBEs are often expected to comply with or participate in those goals or metrics. Employees virtually always count towards these. Independent contractors rarely do, and I put a little asterisk here because there's been a bit of confusion coming out of the FHWA as to how much leeway they'll give a DBE that uses independent contractors because they can't necessarily afford a proper full-time staff of employees. There is some latitude there, which I can't really get too much into, but it has to do with control, essentially the exercise of control, the ability to exercise control. By and large, though, employment related contract goals typically require the actual employees and not independent contractors. This is more important in some contracts than others. It's important to understand the contract and to read the room with your contract, but just understand that this distinction does matter for those contracts, just like it matters for you as an employer. The big reason people try and get out of being an employer and use independent contractors instead is if you have employees, you have to withhold and remit taxes, income tax, Social Security and Medicare taxes, workers' comp. You have to get workers' comp insurance. In this state, if you employ 3 or more workers, though I recommend you get it from the jump if you have employees, because you don't want to have 2 employees, no workers' comp, and one of them gets injured. You have to pay into the federal and state unemployment insurance schemes. You have to adhere to minimum wage, overtime, and other wage laws, OSHA, ADA, employment laws, the Americans with Disabilities Act, the ACA, the Affordable Care Act for employees. I mean, there's a lot that you as an employer have to do. So it's understandable why a lot of folks don't want to use independent contract, or they don't want to use employees. They want to use independent contractors, but at the end of the day, it's just not always possible. And so the point of this presentation is to emphasize to you that these tests are here, they're real, and if you fail them, the person you're hiring has to be treated as an employee. If you treat them as an independent contractor anyway, you do so at your own peril, because misclassification comes with a lot of penalties and fines and often back due taxes and so on. So really, if they're an employee, treat them as an employee. Like I said, the government has a lot of interest in this, a lot of governmental entities. These are just a couple, these are just a handful of them. A lot of government entities will make a fuss if you've misclassified employees. A big implication, especially for the room here, private insurance. Most businesses carry commercial liability insurance or, commercial automotive insurance, trucking insurance, insurance to cover the job site, the construction project, you name it. These insurance policies are very specifically written, and a lot of them will exclude the use of independent contractors, or they'll exclude the independent contractors from the umbrella of coverage. If you have independent contractors, the assumption is they'll have their own insurance. So if you're using independent contractors, keep in mind, you're going to make sure that they have their own insurance, especially if you're using them as subcontractors on a job. Typically, prime contracts with their pass-through requirements will require that you have insurance and that subs have insurance, or that your insurance will cover it. Again, it varies by contract, but the idea is if you're using subs on any project, regardless of the nature of the prime contract, you want to make sure that they're insured so that if they screw something up, if they just disappear in the dead of night and don't finish the job, you want to make sure they're bonded. There's a lot of that. So employees typically are covered by your business's insurance. Independent contractors typically are not. Yeah, just do your due diligence, do your legwork, make sure that if you're using subcontractors, that they provide you with proof of their bonding and insurance. There's vicarious liability. If you employ people, you as the employer are typically responsible for their negligence. If they do something within the course or scope of their employment, let's say they're driving the truck to a job site and they're drunk and they cause a car accident, you as the employer are typically going to be responsible for their conduct and for those damages, which is, for one, why you have insurance. But just keep in mind that employer liability is real. You're typically not vicariously liable for your independent contractors. There's some exceptions to that, and again, in those kinds of lawsuits, you look at whether they're misclassified or not, because the person suing really wants them to be an employee so that they can go after you as the employer. So that's another instance where some of those tests might come into play. But independent contractors generally are responsible for their own conduct or misconduct. There's always exceptions. There's comparative fault that could still put you as the hiring party in legal jeopardy, because you might be comparatively at fault alongside your independent contractor. So there's no winning in a sense, but you're typically less exposed with independent contractors than you are with employees. Building owners, yeah, I mean, there's some other exceptions. If you have an independent contractor doing work for you and they create a hazardous condition in your building that's open to the public, and then that injures someone, even though the independent contractor did the work, it's still your building, you're still responsible. There's some similar consequences for job sites. I mean, you need to make sure that the end product of the independent contractor is, safe and fit for purpose a lot of the time. So just keep in mind that even using an independent contractor, you're still ultimately responsible for certain facets of their performance. There's other means of liability that I'll just kind of gloss over here for employees and for independent contractors, but especially for employees. If you hire them as employees and you don't do a good job of vetting them, checking their background, and then they do something that would have been predictable had you checked their background, you could be liable under negligent hiring. Independent contractors, there's usually less of a standard in vetting for independent contractors. The assumption is you're just hiring them for a specific business purpose. Who they are as individuals isn't really your problem as long as they can do the job. And then, reputational fallout. If you have bad employees, they can damage your reputation publicly. Same is true with independent contractors. It's easier typically to fire independent contractors than it is employees. You've got wrongful termination and unemployment insurance claims that come up with employees. Independent contractors, wrongful termination might be a breach of contract if you're promising to keep them on for a term. So you're not going to win either way with this. Just understand there's differences between them. There's no one that's better as far as how you get rid of them, in my opinion. And finally, job references. You have some legal cover if an employee asks you for a job reference, or a new employer of theirs. There's a statutory exemption for defamation if you're providing an honest job reference, as long as you're not doing it with malicious purpose and you're not violating any of their civil rights, namely the ADA, HIPAA, anything like that. If you're just providing a good, honest job reference for a former employee, you're basically shielded from defamation or liability for doing it. Independent contractors, if you hire an independent contractor and they go to a new customer or client and they ask you for an analysis of their work, like how were they, how did they do, and you give them the honest truth, they were terrible, they showed up drunk to the job site, you could be at risk for defamation lawsuits. There's no shield for independent contractors. So just a little tidbit of info there. Be careful giving job references for independent contractors. Finally, some FAQs. These are questions that I've gotten recently. Is it a good idea to cover independent contractors under a workers' comp plan? Generally, no. In fact, most workers' comp plans exclude them in the first place. Including them may lend itself towards the perception that they've been misclassified. Workers' comp plans really are for employees. You typically won't see them used for independent contractors, and often they can't be. Can I provide independent contractors with the equipment needed to operate? As we just covered, you really shouldn't. Can you, in some cases, yes, but you really shouldn't, because it weighs in favor of an employment relationship. Does a pass-through requirement in a prime contracting requiring that subs be bound by the applicable agency rules mean control? Like, is that an assertion of control such that they're employees? No. No, it's I'd call that non-contributing, or it really, optics-wise, it suggests that they really are subcontractors, because you are doing the minimum required under contract to keep them in line with the prime contract, which suggests that apart from that, you're really not exercising control. You're putting the onus on them to comply with these rules as a matter of contract. It's a weird nuance, it's a weird needle to thread, but no, you shouldn't be afraid of including the relevant pass-through clauses. And now we get to Q&A. So I'm going to open up the Q&A window. Go ahead and ask your questions through Q&A. I see someone already asked the counter, should I provide workers' comp for my subs? No, if they are in fact independent contractors or subcontractors. What if my firm is the only client the sub has by choice? They are retired. That's a good question. That's not dispositive, because they still have the option or means to market themselves more broadly if they choose to. However, while it's not dispositive, it does weigh in favor of employment versus independent contractor, because if they're exclusive by choice, you look at the nature of the relationship between the parties under the IRS test and under the economic realities test, more the IRS test than the economic realities test, but at least with the IRS, they might look at that and think, well, even though they could be an independent contractor if they marketed themselves, they're really not, and they have no intention to, so they might be an employee. Again, it's not dispositive, but it doesn't work in favor of independent contracting. Do I have to have a formal contract written with my sub? Not for purposes of these tests, but just as a separate legal matter, you absolutely should. because if you don't have a formal written contract with your sub, they can get away with a heck of a lot under the guise of, well, I'm independent and I was doing the job at my own discretion. The reason you want a written contract with your sub is because you want to be able to set minimum quality standards for deliverables, not necessarily for the tasks that they perform, but the end deliverables need to be up to a certain spec or quality or fit for a particular purpose. And then there's the whole liability thing. You want to make sure the sub is assuming liability for their work, for any harms they do to third parties, and for the conduct of their employees, for injuries by their employees. You want them to promise that they're covering their employees with workers' comp and that they will shield you from lawsuits by their employees. I mean, there's 1,000 reasons why you want a good written contract with your sub. The next question. I let my sub have flexibility, but require they comply with agency rules. Are you controlling? No, you're not controlling in that instance. It's again, it's a weird nuance, but requiring compliance with law is not control. It's essentially a CYA protocol that is widely recognized as appropriate in pretty much every contract, employment and independent contractor. Financially, it makes no sense for some of my subs to carry NMDOT insurance like professional liability due to cost. My insurance company allows coverage to trickle down. Is that okay? It is okay to an extent. This is where you start looking at the totality of circumstances. So if your insurance company allows the coverage to trickle down, acknowledging that they're independent contractors, it's still a point against you because you're providing the insurance that allows that sub to do their job. So the question then becomes, in my mind, and I think this is how the analysis would go, is that sub doing jobs for other parties? Are those other parties providing insurance for them? Are they providing their own insurance for those other parties, or the hiring entities? Or are they just providing services to you covered by your insurance? Because if they're only providing services to you and your insurance is trickling down to cover them, that to me leans more towards an employment dynamic, maybe limited in scope, but still an employment dynamic. So you really have to look at some of these other factors and ask, really, are they independent, or are they really employees? Another question. I was involved as a juror in a case in the transportation industry. The decision of the relationship was determined by the confusing language of the contract. I love it. One section said X was allowed and the other part said X was not, without explaining the rationale behind the ambiguity of the clauses. We, the jury, found that the reason for finding the contractor was an employee. Was this finding sound in your opinion? Yes, insofar as any jury finding is sound. Juries can do some pretty bizarre things, but in this case, if I'm the jury and I'm looking at that, there's a presumption under the law of employment. I mean, that's just the reality. There's a presumption that there's an employment relationship because an independent contractor is, someone who's not an employee. So if the contract is confusing and it leans both ways, you're almost always going to get that presumption of employment, and it's going to be overriding. This is why you need to hire a lawyer who knows what they're doing with these contracts. And this is why you should error check it, because I've seen lawyers make that very mistake where one part of the contract says independent contractor, the other part says we will control the following manner, or employee. The contract governs first. So if the contract says employee, hard stop. That's the end of the analysis, at least in most cases. So what if an independent contractor refuses to complete a W-9? You don't hire them, you fire them. They're not compliant with tax law. A W-9 is a legal requirement that they have to do so that you can issue them a 1099 If they don't do a W-9, you don't have the relevant information to provide a 1099 to them and to the IRS. And so, you know, you can, of course, report the issue to the IRS. You can issue a 1099 without the relevant information. It's bad form. It's going to give you some headache with the IRS. Typically, that to me is a red flag. If they're not willing to provide that information, it's because they're probably not reporting the income, and you just don't want to get roped into that. Clarification of the previous question. We found that the confusing language is the reason we found the contractor was an employee. So you found that they were an employee because of the confusing language of the contract, if I'm understanding this right. And that's a natural outcome. I mean, it really is a natural outcome. Does this relate to a prime sub sole proprietor extending a project such as installation, initializing, validation, document of first end use into an ongoing operations and maintenance agreement with annual renewals? This is a complicated one. Does pricing have an impact here? Performance expectations, ongoing downtime metrics, performance needs, above average travel costs. So this is a really complicated question, asking to look at kind of the totality of the contract. You know, there's a lot of factors in here: performance expectations, ongoing downtime metrics, performance needs, above average travel costs, higher than otherwise costs, required standards, pass on at the end of initial funding, control versus length of time, etc. I would need more details before giving a real opinion on this. I will say that there are some metrics in contracts that are not verboten. They're not forbidden for independent contractors. A common example is like service provider relationships for, you know, tech services. If you've got a web host with SLA needs, uptime standards, that's a very common B2B relationship. Uptime standards, certain quality metrics of the deliverables, those aren't control factors necessarily. Governing how they provide the services, like saying you are going to do this, and this to ensure quality, that's control. But just saying the deliverable will be fit for this purpose and it's going to have an uptime of like 99% or whatever, that's not necessarily control. Is there a percent of subs income test? Not necessarily. That will be a pretty hard and fast rule. You do look again at whether you're the only provider the sub is providing services for, because then that's 100% of their income. But again, that's not really a dispositive factor. You weigh them all in the economic realities test, and you weigh them all in the IRS balancing test. So, if the subs, if 100% of the subs income is from you, that definitely weighs more towards employment. But that, again, is not dispositive. That's not going to result in an automatic declaration that they're an employee.
So I think that was the last of our questions.